Okay, I'd like to welcome everybody to the Town of Shelburne Development Review Board for Wednesday, December 18th, 2019. And before we proceed with the agenda, I think we've got a couple of items to add to the agenda, one of which is board reorganization discussions. And then I see there is an email here for an extension. Is that an add to the agenda?
That has been added already in the revised agenda that it's been given to you.
Okay, is that number 8?
Number 9, it's under other business.
Okay, I see it. Great. Okay. So we'll.
I'd like to suggest maybe the organizational discussion occur after item 8.
After item 9
Or, well, 9 actually,
Yeah.
sure.
So
Or as part of item 9. it's
Okay,
cleaner.
so everybody approve of discussing board organization as part of item number 9? All in favor?
I'll second the motion, and I'm in favor.
Good.
Aye.
Aye. Okay.
So, motion to approve the agenda as revised.
Seconded and approved.
Okay. Very good. Okay. Just want to remind the public, there is a sign-in sheet there on the table clipboard. If you please sign in, would appreciate it. And then also would like to request from the board if there are any items being discussed today where you believe there's any kind of conflict of interest.
I have none.
Good.
I don't have a conflict of interest. I will disclose for the record that I do business with what is now Safe Harbor Marina, which is a co-tenant with Lake Champlain Transportation Company for one of the pieces of property here.
Okay.
But I don't see any conflict in that whatsoever.
Okay.
I'm in the same boat.
Nicely done.
Boo, boo, boo.
Well, you're in your own boat.
Couldn't read this.
You're not going to sink that one, huh? Okay, is anybody from the audience that believes any board member should disclose any conflicts of interest? Okay. Hearing none, we shall proceed with the agenda. And the first item is approval of minutes?
For a minutes taker, I advise that all of you would speak up and speak into the microphone so that way it'll capture the voice the best as possible.
Okay.
And I'd also observe that when we're really reading the draft language that the staff has provided, saying that allows whoever's transcribing this to proceed much more quickly.
Okay. Duly noted. Minutes of December 4. Any comments, changes from the board members?
Motion to accept the minutes as written.
Second.
All in favor?
Aye.
Aye. Approved. Okay, our first agenda item is application sub 19-03, application by Civil Engineering Associates on behalf of Laurie and Mark Kotorman for sketch plan review of a proposed 2-lot subdivision. Property at 1 Nashville Road is located in the residential district, stormwater overlay district, and floodplain and watercourse overlay district. Ravi, this is continued?
Well, this has been continued multiple times.
Yes.
Originally heard on March 20th, 2019, but presently the applicant is here to talk about the item. This is to refresh your memory. It's a 2-lot subdivision proposal at 1 Nashville Road. The plans are behind me. These are the revised plans that were submitted to me last week. The items that from that meeting that still need to be resolved include a classification of the subdivision proposal. Staff recommends that this be considered a minor subdivision because it's a 2-lot subdivision. And also, during that meeting on March 20th, there was a number of abutters that came out and voiced some concerns, and that's something that the board needs to resolve as well. The only concern that staff noted from this application had to do with the location of the driveway and the sewer line, and staff recommends that the applicant should modify their site plans to minimize any stream crossings. At this point, staff will defer to the applicant.
Okay. Question, though, before we proceed. So we had this email.
Oh, yes, right. So this was written testimony provided to me on Monday night that I opened up on Tuesday morning from the neighboring property owner, Piper Abbott, that will be added into the record for your review.
Okay.
Thanks.
Okay, sorry.
Very good. For the record, Dave Marshall from Civil Engineering Associates.
Yep. Okay. Do you hereby swear or affirm that the evidence you give in the cause under consideration shall be the whole truth and nothing but the truth under the pains and penalties of perjury?
I do.
Okay.
Very good.
Very good.
So Revy summarizes the conditions well. To orient you, this is Spear Street. North is up on this particular plan. This is the mobile home park that's just to the north of the Bishop Road intersection. This is Kalady Drive that runs down into a multiple lot subdivision that was permitted back in the 1995-1996 era. This application seeks to create a two-lot subdivision, of which one of the lots is outlined in yellow here, with the building envelope approximately located here. Since we appeared before you back in March, the applicant has asked our office to locate, first of all, they had their contractor locate what would be the preferred route for the driveway as a means of saving as many trees as possible. That was one of the concerns of the neighbors, was to make sure that whatever was done here wasn't going to open up views from their homes into the mobile home park. And so we basically went out and located all the trees at this particular location and have realigned the driveway on the plan to identify the ideal route in regards to, again, the retention of as many trees. And at the same time, the site contractor also mentioned that the concept of providing a gravity sewer service from this particular location out to the existing pump station created a very rigid alignment issue, which doesn't go around trees very well. So his recommendations is to basically, and at the same time, to provide some flexibility as far as location of the building envelope or the actual home itself, is to basically commit to a pump station and a force main. And the force main can basically follow the disturbance area associated with the driveway and then tie into the existing infrastructure from there. So those are the updates that we offer the board. And at this point in time, are looking forward to moving forward.
Okay, thank you. Any questions, comments from the public?
I'd like to ask a question, Dave. In general, if you can refresh my memory on how this has changed from the original plan and when we had our initial site visit. Has there been a significant change in the road alignment?
I think in this particular case, it's very similar.
Okay.
It just has perfected the alignment of the driveway. Whoa, come on, you can do it. There we go. Nope. No, it just doesn't want to work. So there we go. So we always were coming from this particular location and getting to here. So at this point in time, this particular alignment has been updated. Otherwise, the termination point and the beginning point are the same. We would be utilizing an easement across this portion of the access off of Spear Street. And I think the biggest change actually is the elimination of the gravity sewer component in favor of the pump station and force main. So the other thing that was discussed, or is at least in the staff notes, is the proposed culvert at this particular location. And one thing of interest is that this particular area, first of all, doesn't show up as a stream on any maps. So back in the old days, we would use the USGS maps as being the template. That's what the state of Vermont said. If it's a blue line on that map, it's our jurisdiction, and it's a stream. Well, it doesn't show up on those particular maps, and we can produce those. But at the same time, under the current GIS database of the state, the Natural Resources Atlas, they've got more streams on there than even exist. So I went to take a look at that particular one, and this area doesn't have a stream on it. It is a drainage way. It drains about 20 acres, and basically there is an existing culvert for Kalady Drive, mainly because 20 acres draining through the particular area under the right conditions can be a problem. So they installed a culvert, and the kotormans would also propose a culvert, but there's not a stream here. We're still sensitive to basically making sure it's sited in the appropriate way, but there's not a stream, there's not a eroded channel. It's basically just a drainage way. So we just wanted to bring the record clear as far as that's concerned, and anyways, I think that was the last clarification on one of the recommendations from staff in regards to conditions of approval moving forward.
Yeah, so there's really just one additional crossing.
That's correct. You know, the real environmental resource is Monroe Brook that runs through this particular area here, and that's a substantial stream. But nonetheless, that's what struck me even when I did the site walk. I'd never, even though our office did the work for Kalady Drive, I had never been out there myself. But when I went out there to see the kotormans, you know, I noticed, the size of the culvert that was under Kalady Drive, and then I said, what's up with this? But nonetheless, when I went back and researched the issues and as far as the contributing drainage area, it would say that you needed a pretty good sized culvert. But again, the characteristics of what you would expect to have a stream channel there wasn't there. So it was just very curious, and I can certainly understand where staff was coming from with the comments.
Okay. Any other questions, comments from board?
I'm good.
Okay, board's good? Yes, sir. Yep, if you'd like to come forward, please.
I'm Matt Chandler. I'm
Okay.
one of the residents in Kalady Drive.
Okay, got to read you your rights here.
Yep.
Do you hereby swear or affirm that the evidence you give and the cause under consideration shall be the whole truth and nothing but the truth under the pains and penalties of perjury?
Yes.
Okay, thank you. Go ahead.
I had one comment, and I wasn't disputing the GIS maps, but as someone who's lived there for 20 plus years, it is not one of those things that dries out ever. So as far as like a drainage system, it's constantly draining. So I don't know exactly what the official definition of stream is, but I know from experience that there's always running water through that pathway. I don't know how that impacts you. And the other comment I had was last time we met in March, and when you folks came to do the site walk with us, which was awesome, we talked about the buffer that we wanted to maintain between the residential neighborhood and then the trailer park. And I just want to make sure that this plan honors and enforces maintaining that buffer in some way. The trees that are currently marked, as you've talked about, winding through the trees is great. We certainly appreciate that. But I don't know what the long-term effect of the construction so close to all those trees is going to be. So I would ask that maybe in the plan there were some conditions on making sure that we had a replacement of trees that are damaged and taken out, so that that buffer, the visual buffer between the Kalady Drive neighborhood and the sort of new viewscape of the mobile home could be preserved.
Okay.
Thanks. Thank you.
The applicant is happy to comply with any of the subdivision rules or the zoning bylaw requirements in that regard.
Okay, question for you. I'm just curious. I'm not a hydraulic engineer, but what would be the issue about having another culvert there? Do you know?
Having, I'm sorry?
Another culvert there.
So for streams that carry aquatic animals that basically move up and down the corridor, when you design a culvert, you want to make sure you've minimized the impact. So anytime you can avoid a culvert, avoid a stream, it's ideal. So in this particular case, there are no fish in the stream or anything of that particular nature. So I'm less concerned. I mean, there are written standards from Fish and Wildlife on how to basically design culverts in this particular area, and things that you'd want to do is avoid vertical elevation. So if an animal does want to use that corridor and dares to go through a culvert, you've minimized the vertical obstructions for that. So
So any culvert that would go in there would be designed per those standards?
I think
take
that's
it.
something we're very comfortable complying with.
Yeah.
It may not be written in the rules, but that's one we're very comfortable committing to the board as far as how that would be designed.
Okay.
I mean, culvert is going in.
I'm sorry, Doug?
Culvert will go in.
Yes, well, it needs to go in
Needs to
other
go in.
than, yeah, otherwise the driveway will get washed out.
You don't
Right,
have a culvert,
okay.
You're gonna have a pond.
Right.
Right.
And then you have a wetland, then you have a problem.
Thank you. Point well taken.
Okay. Any further comments? Yes, sir.
My name's David Abbott. I am also a resident in Calady Drive.
Okay, David, do you hereby swear or affirm that the evidence you give in the cause under consideration shall be the whole truth and nothing but the truth under the pains and penalties of perjury?
Yes. First, I just have a general question about this process. Like, what are we actually voting on here tonight? Are we voting on something? And if so, if it were approved, what would we be?
It's a sketch plan, then it goes to final plan. Then they come back in with a final plan, and we get to talk about it all over again.
Sketch plan basically just approves them moving forward with the process and providing us more details.
Right.
So it looks close enough to okay so that we're willing to let it go to the next step. That's what gets voted on tonight.
And what more information do you guys need to make that assessment? Like, do we need to know, like, whether they're gonna run a business out of that property? Whether they're gonna construct a duplex or an apartment building, or whether it's gonna be owner occupied or anything like that? Like, those are kind of the big questions that I have. What's gonna happen on that property? It's right across my house is the little one you can see at the very bottom of the screen there. I'm directly across the street from what's going on here. I will, I've walked those woods. I know what trees they're talking about cutting down. I will have a direct line of sight into the trailer park. So I have very serious concerns about all of this. My wife is Piper Abbott. She asked for the continuance via email a couple days ago. And concerning that, as Ravi said, this meeting has been continuanced, if that's the right word,
Continued.
over and over and over again. And we didn't realize it was happening this week until Thursday when we got an email from Ravi, which is pretty late notice, no offense, but subsequently a lot of people aren't here. Like, more than half of our neighborhood is not being represented. Some are out of state, one's having surgery. Some folks just moved in. So we're not very well represented here, and I would like that to be considered.
Ravi, could you elaborate on sketch plan versus, say, preliminary versus final? Would that be helpful? This is like pre-preliminary where we're at.
This is a two-step process.
So,
This is a minor, so it's sketch, final.
Sketch to final, okay.
yeah, so sketch plan is to test feasibility. It's a rough draft. It's a very rough draft. You're given one plan and you're saying, and the applicant's saying, this is where I want to draw the lines, and you're looking at it and saying, well, have you considered these things? Have you considered that? What about this? What about that? You're giving advice to the applicant on things that they should consider, and the public is also giving advice to the applicant too on things that they should consider as well. So please, the more voices the merrier in this case, because the more input that the applicant has, the better the design can be. And it also questions whether the project's even feasible from the get-go. So this is the main test of whether the project is even possible or not. And if it is possible, then how can we make it better? And then after that, in this case, it's a combined preliminary final. That's how we treat it. It's a combined preliminary final where the applicant's responsible for all the preliminary plan requirements, but also all the final plan requirements as well. So they'll come back with comments from all of our major departments. The applicant's required to go to the fire department, sewer, police, water, schools.
Finance.
Yeah, 9 departments, so I can't remember all of them. And so they have to get comment letters from all of them to test the impacts that the subdivision would have on town services. They're also required to come back with probably 8 or 9 plans that are different layers, such as stormwater plans, erosion prevention, sediment control, topo, a plat, so that way we see what easements there are on the property, whether there's stormwater management actually being considered, whether the lines actually make sense, really, because that's when the applicant's going to go out there and actually put pins in the ground and survey the land to see if the lines are correct and whether the lines need to be nudged a bit or not. There's a lot more polishing and perfecting involved in between now and preliminary final. And with their preliminary final application, if you go through our regulations, they're required for like 30 items in a list. So it's a lot more rigor, there's a lot more components, and there's a lot more work that the applicant has to do. And given the comments that you've provided and the public has provided, that they have to take in and then come back to you within 6 months.
So in brief, I think it would be safe to say that any interested party, this would be the point where you should express any comments or concerns that you feel should be incorporated into the design. Is that
Absolutely.
correct?
Yes.
That said, though, just to be clear, Robbie, the board's approval of a project at sketch plan doesn't mean the board can't reject it when they have the combined preliminary final, depending on the additional input the board gets between sketch and preliminary final, right?
Yes.
So there's nothing that's locked in tonight except the ability to go to the next stage of the process.
But
Right.
again, we are underrepresented tonight.
Robbie, they can submit written comments
Yes.
between now and any time, right?
Yes. Written comments have the same weight as oral
Right.
comments. That's why I forwarded you the written comments that I received. That should be included in the testimony of this
Okay.
record.
So I recommend that all the neighbors send in their comments and what they find are serious or even minor problems. So we get a chance to read them and bring it, and you get a chance to see them and make the plans go forward.
That's correct. No, as Ravi points out, there's a lot of heavy lifting to be done to demonstrate compliance with both the subdivision regulations as well as the zoning bylaws. So there's a lot of work that's done to that, and there'll be a lot of paper that is submitted back to the board to demonstrate those compliance issues.
Any further comments, questions? Any from the board? And if none, any board member wish to draft or
I would like
offer a motion?
to make a motion.
But before you do,
Oh, you have a comment?
I do. The comment I have is that, and it doesn't need to be reflected in the wording of the motion, but I think you'll take it to your clients and give it the consideration that you think it should be given. And that is, I wanted to emphasize that any diminution of the visual barrier that exists now between the existing houses and the trailer park should be addressed in your plan. The ideal plan from my perspective is that there would be no significant increase in the view of the trailer park from the road. Now, whether, that's possible, depending on how many trees are actually taken down or not, I mean, that's something that, the final plan will be a better chance to look at because you'll have much more data and a much more detailed layout there. So I'm not suggesting any changes. I'm just flagging that as an issue of concern to me.
We understand that, and I think we've taken the first steps to demonstrate an effort to comply with the minimization of tree removal, but at the same time, our job is to demonstrate compliance with the rules. And if there are specific requirements of that, we have to meet that requirement. But at the same time, we will be going above and beyond that based on what we've already done. So that being the background, we understand where you're coming from. Just understand that also we need to follow the rules too.
Yep,
Thank you.
all yours.
Okay, I'd like to move to classify application SUB 1903 as a minor subdivision, and a motion to authorize which is, where did I see? Oh, finalize the record and close the hearing. There we go. And then I'd also like to move to direct the staff to to prepare a decision authorizing applicant CEA Associates, Inc. on behalf of Laurie and Mark Kotorman to prepare final application for SUB 1903. The following recommendations. They are listed. Should we state them?
I think
Okay.
you can state that there.
There's 1 through
Staff report.
6 recommendations that should be put into the record.
Yeah, do we also want to add, I think we had one comment that we want to make sure that the buffer situation is addressed.
I have to agree with David. I mean, we have to, he's got to do whatever needs to be done to comply with the rules, so rules are the rules.
Okay, well,
Anything beyond that would start to get subjective, I think. But
Yeah, I'm
Okay.
fine with the draft language.
Okay,
And the comments, I think the comments are as important, and I know that the neighbors will file written material between now and the next hearing, which will give the board and the applicant additional opportunity to consider their points of view.
I'll
Okay.
second that motion then.
all in favor?
aye.
Okay, the motion carries.
Thank you.
I will move out of your seat. Before everybody goes, I don't know if you know that Ravi's last day here before the board.
Oh, yeah, we heard that rumor.
Not yet?
Heard some rumors.
Okay, fair enough then. I'll
We're going to eat the cookies and enjoy his last board meeting.
Okay, we'll move on to the next agenda item, application sub 1302R4, application by Civil Engineering Associates on behalf of Shelburne Green LLC for final plan review for proposed two-lot subdivision. Property at 120 Graham Way and Sage Court is located in the Commerce and Industry South District and Stormwater Overlay District. Ravi, take it away.
Yeah, so this is the final plan review application for a subdivision that last came to you in May. It's a two-lot subdivision. They're simply drawing a line dividing I think it's Phase 1 Shelburne Green North portion of this parcel, and Phase 2 Shelburne Green South, which is the southerly portion of this parcel. At the moment, staff has only one concern, and that has to do with the legal documents for road, sewer, and utility and stormwater easements across both proposed properties as of yet. Staff's understanding is that both lots would be owned by the same owner at the moment, but staff's not sure if that would ever change ownership, and therefore we would like the security of having those legal documents reviewed by the town attorney before any changes in ownership occur at any time in the future. So that's one thing that staff has recommended in its suggested conditions of approval to you. At this point, staff will defer to the applicant.
Okay, Dave?
Very good. For the record, Dave Marshall from Civil Engineering Associates.
Didn't we already swear you in?
Does it carry over?
It does.
All right, very good then. Then we're all square. Norm, do you want to speak tonight?
I'm going to let you go forward.
All right, Norm Stanislaus says he'll defer for now. So in this particular case, Ravi points out that this is the proposed subdivision line. So this is the original light industrial facility that has currently been converted into a number of commercial uses and spaces. And this is what we call Shelburne Green South. And this is, you've seen this many times. And in this particular case, we're looking to create a subdivision between the north portion and the south portion. And Ravi brings up an excellent point as far as making sure that the legal documents that allow for any cross use of the properties are in place. He mentioned that perhaps they needed to be done before a transfer of ownership. We actually prefer to have them done as prior to the filing of the Mylar, only because Mylar is not
Likewise.
Doesn't work without the appropriate, without the supporting documents. So in this particular case, points of interest in our meetings with staff was a discussion with regard to parking. And we found that over time that this particular north area is working very well with regard to the amount of parking that's there, as well as what's happening on the south side. But we also recognize that under special circumstances that the PUD needs to be reviewed as a whole. And that the ability to basically cross the line under certain circumstances to utilize the infrastructure that's available is an important component of the PUD. So we will be developing documents for submission to the town attorney to basically make sure that those particular goals are being met with regard to the proposed documents. So we're very comfortable with the staff recommendation as far as the condition of approval on that end of things.
Okay, thank you. Any questions for Dave from the board? Comments, question from the public?
I'll just say one thing, I would just, a friendly recommendation on condition number 2 that reads that easements must be submitted, reviewed, and approved by the town attorney before a Mylar is recorded.
I would agree with that.
Would throwing parking in the list of things simply address the conversation we just had about having the legal documents relative to parking access be approved in advance?
Sure. So one of the conditions of their preliminary plan approval was to provide legals for parking. So that has been enclosed in your packets, and it's executed that there is this cross-parking easement already in place. So any additional legal documents that the applicant would give you, you can put like an et cetera if you'd like. But in terms of parking
Well, do
specifically.
the documents already in place cover what happens if the ownership is separate?
I believe so, yes, based on my understanding. The applicant can probably add more information about that too.
Okay, so maybe I misunderstood the prior conversation. I was under the impression that we needed to have in place documents not presently done yet
Yes.
to provide access to parking by south to
Yeah.
the parking areas on the north. Now, are those documents actually already in place, just not yet reviewed?
They've been signed, but they haven't been filed.
Okay.
So they were submitted as part of the final plat application because that was a condition of preliminary plat, was that we come forward with that particular document. Subsequent to that, staff has said, hey, let's fill in the blanks with all the other components because there's, access components, stormwater components that basically cross the line and that those need to also be provided. So at this point in time,
So it's bigger than just parking, it's a bunch of other potential issues.
that's correct.
Yes.
So then I think
once we're
the
not
et cetera solution is the most word efficient one.
Okay.
Okay.
Subject to that addition, are there any other suggestions about the wording of any motion to approve?
Can we make this simple, and just say legal documents related to any easements? And just make it wide open. We don't minimize it, we don't.
Or you could say in stormwater and other easements, or any easements is fine. That's better, yep, any
Just
easements.
make it any?
Yep,
So condition 2 would read all legal documents related to any easements
right.
on the any easements, period.
Must be submitted, blah,
Must
blah,
be
blah.
submitted and reviewed by town attorney.
Okay, that makes it.
Submitted, reviewed, and approved.
Can we require approval by the town attorney?
Yes, generally the process is a conversation of sorts between the town attorney and the applicant's attorney. So some sort of resolution usually happens where both sides come to approve it, I guess.
Okay, as long as we're not crossing a bright line there, then I agree with Mark's suggestion that the language should say submitted, reviewed, and approved.
Okay, good with that?
All right.
You ready for a motion?
Well, that being said then,
Anybody from the public?
I don't think anybody had any comments, did they? Okay. So then I would make a motion to finalize the record and close the hearing for this application. And I would also move to direct staff to prepare indication of approval of this application, SUB 1302R4, with the two conditions as drafted and per the revision we just discussed. Fair enough?
Seconded.
Well, and I was going to suggest, just for clarity, I think I'll say out loud what we ended up with as the wording of the second one. All legal documents related to any easements must be submitted, reviewed, and approved by the town attorney, et cetera, et cetera, et cetera, as per the staff recommendation. So those were the changes that I had written down.
Agreed.
Agreed.
Okay, so
Seconded. Okay, all in favor?
Aye.
Any nays? Motion carries.
Thank you for your time.
Thank you. Okay, next item is application CU 16-01R1, SP 19-13, application by Lake Champlain Transportation Company for conditional use and site plan review to modify non-conforming structures that host a conditional use. Property is at 4650 Harbor Road, is located in the Rural District, Lakeshore Overlay District, and Floodplain and Watercourse Overlay District. Okay, Ravi.
So the applicant's looking to renovate and expand their warehouse shed. It's labeled as the shed on this site plan, and then the hauling house as well. The shed they're looking to expand by about 325 square feet. The hauling house, it would be about 800 square feet on top. So they're gonna, it's currently a single-story building that they were gonna make 2 stories. The use of this property dates back to 1820. The wheelhouse dates back to 1945. The warehouse dates back to 1925, based on our records. The only concern that staff really noted about this application came from the water quality superintendent's review for stormwater impacts. He recommended that that erosion prevention and sediment control be considered during construction. And so staff recommends an erosion prevention and sediment control plan with their zoning permit application. At this point, staff will defer to the applicant.
Okay. Have the applicant. Okay. Do you hereby swear or affirm that the evidence you give in the cause under consideration shall be the whole truth and nothing but the truth under pains and penalties of perjury?
I do.
Okay, and introduce yourself.
Yep, my name's Russell Fox, work for Lake Champlain Transportation. And this is our dry dock facility where we haul the ferry boats out. And basically what we're trying to do is take an older facility and give us a little bit more workable space. So the shed building itself is a very old building, single level, no weather protection at all. It's not an insulated building. And we're just trying to provide ourselves with a building where people can have working tools and a shop where we can basically work on the ferry boats in a warm environment. The other building, the hauling house building, basically most of the interior portion of the building itself is a hauling winch. It's a very large electric driven gear reduction winch assembly. It doesn't provide a lot of space inside the building for lockers or an office or place for tables and stuff. So a second floor would allow us to have some additional space. So.
Okay. Any members from the board have any questions? Comments?
Straightforward to me.
Yep.
Bobby, I surmise from the wording and your staff comments that the staff's position is this doesn't increase nonconformity, right?
No, this does not. They're just building up for the hauling house, so it doesn't encroach in the setbacks any further. With the warehouse shed, they're actually building away from the lake, so it doesn't increase any nonconformities there, and
Right.
it's not moving any closer to the side yard setback, so.
Yeah, that's what I thought. I just wanted in the record that there's no increase in nonconformity
Yep.
with the plans as submitted.
Okay. Do we have any comments, questions from the audience? Okay. Do we have any motions from the board?
I don't know if I can find Robbie's draft language, yes. I'll make a motion to finalize and close the record of the hearing, and further move, referring to the language in the staff report, to direct staff to prepare a decision indicating approval of CU 16-01R1 and SP 19-13 with the listed conditions, the second of which has the inclusion of an erosion prevention and sediment control plan, but the wording I'm proposing is that was drafted by the staff for those purposes.
Second.
All in favor?
Aye.
Motion carries.
Thank you.
Thank you. Okay, next item is application sub 19-12, application by Lemro and Dickinson Consulting Engineers on behalf of Jerker Todian and Rebecca Britton for sketch plan review for a two-lot subdivision of property at 193 Harbor Road is located in the Village Residential District, Village Design Review Overlay District, and Stormwater Overlay District. Robbie?
So this is a proposal for a two-lot subdivision with Lot 1 being 2 acres, Lot 2 being 1.5 acres. So the southern lot's 1.5 and the northern lot's 2 acres. Currently, the lot hosts a single-family dwelling use, it's non-conforming use, non-conforming structure. The structure is not being touched by this application. Most of the development that the applicant's proposing is on the southern lot. The only main concern that staff noted about this application in terms of the lot lines and future development is stormwater. And staff recommends that the applicant obtain a comment letter from the town water quality superintendent regarding stormwater management with their final plan application. At this point, staff will defer to the applicant.
Okay, you're on.
You just swear me in with it being a sketch?
Do you hereby swear or affirm that the evidence you give in the cause under consideration shall be the whole truth and nothing but the truth under the pains and penalties of perjury?
I do.
I do. And introduce yourself.
Andy Rowe, Lamer and Dickinson.
Okay.
As Ravi said, this is a 3.5 acre parcel. There is an existing single-family home at 193 Harbor Road on the north end of the property. Very irregularly shaped parcel. The school is located to the west. In the 80s, Tracy Lane was extended and a very oddly shaped cul-de-sac right-of-way was created around this parcel. From what I can tell from the maps of that era, this parcel had nothing to do with it. Exactly how this parcel ended up in that shape may have had something to do with the school or the other parcel being created just to the east. It is in the Village Residential and the Village Design Review District. The house along Harbor Road, as Ravi said, no changes are being proposed to that. That's not currently occupied. There are a couple of nonconformities, potentially the side yard setback, most likely the front yard setback, and until we do a boundary survey, it may have nonconforming lot frontage as well, but again, no changes being made that would either make that nonconforming or any change really being proposed associated with that existing house. A new property line would be created here, creating a a smaller 1.5 acre lot for one new single-family dwelling. Access would be off of Tracy Lane. Most of this property is wooded now. It's got a variety of species on it, but most of those on the south end are poplar, green ash, cottonwood, not exemplary hardwood species by any means. There is a drainage way that comes across the railroad and comes down this property line, I believe, across Tracy Lane, and then flows in a ditch along the westerly property line. And there is a wetland associated with that. We did delineate that earlier this year and had it reviewed and confirmed by the state. It is a Class 3 wetland, so there's not a statutory buffer requirement associated with that. So we have shown an approximate house footprint and a driveway coming in off of the cul-de-sac on Tracy Lane. There's no work being proposed in the edge of the Class 3 wetland that runs along that ditch. Clearing is proposed, obviously, on this parcel since it's primarily wooded now in order to provide a reasonable amount of yard space. Solar exposure is also very important for the applicant, and also just getting rid of some of those trees that may potentially be a hazard once the area is opened up and, just aren't great species of trees to begin with. The only item I think that Revy kind of highlighted in the staff report, other than making sure that we paid attention to stormwater as we move forward with preliminary and final plans, is the front yard setback. This is, as I said, a very irregularly shaped lot, and right now, this would normally be, if this was any other lot, you would just take this line here and offset it. And I'll get into this discussion a little bit more, but I did want to note that, as we do the property plat and boundary survey, if we end up with an angle point here, an angle point here, that might make this whole discussion moot, because if you've got an angle point, then this would clearly be a front line, and any angle point beyond that would become a sideline. So this whole discussion that I'm about to get into hopefully will be rendered moot, but in case it's not. So the applicant's read on the front yard setback is obviously different than what Revy's summarized in the staff report. And I'm not sure if it was intentional, if I'm reading anything into it, but Revy did say that, he wouldn't be able to approve a zoning permit application, seemed to open the door for the DRB to examine this. And the applicant actually did a little handout that explains it. But really what it comes down to is they're asking for the board to consider looking at the area. A portion of the lot that abuts the right-of-way as the front yard, and consider this, the remainder of that 524-foot-long sideline, 110 of which roughly abuts the Tracy Lane right-of-way, as the side yard. And, the way they've got it drawn, if you look at the green arrows, that certainly far exceeds the front yard setback. And again, they're looking at the distance from the edge of the right-of-way perpendicular back to the house. It certainly is a unique way of looking at it, but we also have a uniquely shaped lot here as well. So we would like your input on that during your sketch plan deliberations, if nothing else. So I'd be happy to answer any other questions.
Is there any reason the house couldn't be moved more to the west?
They can address that in more detail, but the short answer is they're trying to maximize the solar exposure, and they don't want to clear any further than the edge of the wetland. So the further they can move it to the east,
Okay.
the better.
Personally, when I was looking at this, I had to really scratch my head a lot trying to figure this out, but I just feel like when I can see technically where the front yard might be considered, well, that line that's going, northwest, and so you'd have to move the house to the west. But in reality, when you think of front yard, it's kind of like when you're standing in the road or whatever, that's like the front yard. So it's kind of like the front yard is basically from where you're standing in that cul-de-sac and looking in. So to some degree, it's kind of like what's drawn here for consideration. But I guess that's just my opinion. This is such an
Well, it-
odd-shaped lot that I think in reality, what our concern would be is, okay, front yard is front yard from a road, and if I'm standing there looking at it, I think it's set way back.
Is there anything to the east of that house, except it looks just like a very long, thin lot, right?
Well, back here, this is the house site location, so there is another house
Oh, yeah, okay, got it. But it's down.
in the other neighborhood, but it's a little further to the north.
Okay, I
Yes.
couldn't quite see it, yeah, got it.
If you move it to the east, you're moving
Okay,
closer to
because
the
then
other
behind
house.
is that long, thin lot, got it.
Yep,
Correct.
and that's not where the house is going.
No, I know.
And I'm obviously speaking for myself and not the board, but my reaction is that I'm kind of echoing the chair's comment that the front property line is normally associated with road front. And not only does the road end at about where you drew the green arrow, but also it's not a town right-of-way extending further along the property line. It's private property owned by another house. So treating that line as the front yard wall, that may well be semantically the correct way to read the regulations. I just don't have a lot of heartburn about considering a modification for purposes of this piece of property. Now, in a setting where you don't have a DRB, but you have a zoning board, that would be considered a request for a variance.
Not in Vermont.
Okay. So does the DRB have the ability to look at a piece of property and say there are special circumstances around that piece of property that exempts it from mechanical application with the regulations, or in Vermont, the regs are the regs are the regs?
In this case, the regs are the regs are the regs. However, variances only kick in if reasonable use of the land isn't possible. Say that the applicant was dealing with Class 2 wetlands to the west and could not place their house site more to the west than already is. That would be a possible cause for a variance that you would possibly review. In cases like this, when full conformance with the regulations is possible with a house site placement, there's not really too much that you could do.
How far would the house have to move to come into compliance with the regulations?
2 feet.
So I just want to comment on that's just a tentative location. We haven't finalized it yet. So we just don't want to constrain ourselves unnecessarily at this point, since we haven't decided on that location. And in looking at the bylaws, the front yard is defined as between the right of way and the front line of the house, just like you mentioned. So our definition, according to our interpretation of the bylaws, is that the front yard setback is as shown in that handout.
The difficult thing is here is the way the regs are written, it kind of assumes like a four-sided lot, and this is essentially a triangle.
At least a square line somewhere,
Right.
Yeah.
no pointy lines.
Yeah.
Well, is there any, and I'm asking this as a relatively new board member, is there any past practice where this issue has come up in the town? Where, so there's a past practice of applying the regulation the way you read it? Or is this the first time it's come up as far as you can tell?
Yeah, not that I'm aware of. I mean, Mr. Samet might have more to say about this based on his experience as well, but not that I'm aware of based on reviewing the files. It kind of, I think in this case particularly, on the record review might kick in as well, that we have to align the regulations and make a cause based on the regulations in place before we come to conclusions. So that's something to take into consideration as well.
Say again?
That with on the record review, that generally you have to, when drafting decisions, you have to align the permit condition with the regulation in place, that there has to be a reason from the regulations for having that permit condition. And in this case too, there would have to be a reason stemming from the permit, from the regulations in place to give cause for this adjustment.
Because we in effect are acting like a court, we can't have a decision that says, well, we don't like that regulation, so we're gonna let them do it. That's the plain English version of
By
it.
and large, yeah.
All right. So and the definition of the front line is, front yard is,
It is on page,
Staff report 3 of the staff report.
yeah,
Yeah, it's
it's
in
on
there.
page 2. It's also in the applicant's handout as well. A yard on the same lot with a principal building extending the full width of the lot and situated between the right-of-way line of the public road, private road, or right-of-way from which primary access to the principal structure on the lot is obtained, and the front line of the building extended to the sidelines of the lot. I think as the applicant mentioned, the main sticking point here is line, really, that if they find some sort of angle or point that would make this whole point moot, then they would come back
You
in
just
3,
need
4,
like
5
about
months
a
and,
2-inch line there.
doesn't have to be
in the
2.
survey.
yeah,
Degrees.
like half a degree, really.
Yep.
Something.
We find that finding angles is maybe not like the most practical application.
Yeah.
It's kind of silly to go for a 180 angle. It doesn't change really the feel and doesn't really change what the setbacks are there to do.
But if we don't have the ability to be flexible with the regulation, it does change the way the wording of the regulation would apply. So that is certainly something I wouldn't rule out. I think it's premature to have a view on that because you don't know whether there is possible angle there or not. So that's to be determined, right?
Correct.
We also call that right
Hang
away.
on a second, if you're gonna testify, you need to come up and be sworn in and
Okay.
identify yourself, so let's start over. If you have something to say, let's start over, please. Sorry, David, I
Yep,
didn't
no,
mean
I
to.
agree, I was ready to jump in there, yeah. Do you hereby swear or affirm that the evidence you give in the cause under consideration shall be the whole truth and nothing but the truth under the pains and penalties of perjury?
Yes, I do.
And could you introduce yourself for the
Okay,
record?
My name is Jörg Taudin, and we are the applicants. We feel like where the right-of-way ends is where the neighbor's front yard starts, so the right-of-way doesn't continue along the eastern borderline. So how can the front yard be on the east side between the house and the east property line if the right-of-way ends where the cul-de-sac ends, at the front yard of the neighbor to the east? So the right-of-way line must end there. It can't continue on private land, right? So given that, we feel like there's not that much else to it.
It's an interesting reading of the language. I think the challenge is that if there is a single line that extends from the road front, and there is no change in it, it's just a straight line. The quoted language says right-of-way line, so you can read that as meaning a line next to the right-of-way and ending where the right-of-way ends, and I understand that's your argument. The other way of reading it would be if there's a line that begins in the right-of-way, wherever that line ends is where the restriction ends, and I gather that's the way that the staff is reading it. I'm not expressing a view on that, I'm just saying that it seems to me that would be the way to split it up.
Again, how much of an adjustment would it take to put this into compliance?
So we don't want to constrain ourselves at this point because we haven't really figured out the final health location.
The question was, how much?
It's 2 feet.
would you- 2 feet.
It was a tentative location was 28 feet from the east side.
We're talking 2 feet out of, what's that distance there approximately, Andy, across there? If you were gonna guess?
Measured along the back line of the house, from the wetland to the property line. It's about 165.
So I just want to repeat again that it was the tentative house location, so we might prefer to put it closer than 28 feet from the east side. Thank you.
Thank you.
So,
Robbie, other than the issue we just discussed, are there any other concerns that the staff had with the proposal?
Nope, not at the moment.
Well, in your case, not ever. That was cruel, but I had to do it.
Down to the short stroke.
I thought he liked us.
Any comments, questions from board? Yeah. Any comments, questions from the audience? Yes, sir. Okay. Do you hereby swear or affirm that the evidence you've given in the cause under consideration shall be the whole truth and nothing but the truth under the pains and penalties of perjury?
I do.
Okay.
So my question goes more toward, if this lot is not authorized or being able to subdivide, what happens to the whole piece? With the, what's an access, what is the width needed for, from Harbor Road, it's 73 feet. So if this just stays as one lot, which I'm not saying you don't get a home, I'm just curious what would happen if this is not, if you can't have a right-of-way to the end, to Tracy Lane. Does it remain as one home and only the home on Harbor Road, the non-livable residence, if you're familiar with the area?
So let me ask you a question that'll help answer the question. Ravi, is there any question about the ability to subdivide the lot?
No, not at the moment. No.
So clearly under the regs, they have the right to subdivide if they choose to.
Yes, for the lot's big enough for subdivision, and based on the lot layout, and they're creating lots that are in compliance, lots that can be developed. So in the current configuration, it's doable.
Yeah. The only thing I saw here was just the placement of the house, was just the placement of the structure.
Correct.
That's 2 feet too close.
Other than that, there's no, okay. But again, I was just wondering about Lot 1. What would happen with that? That would be a one-structure lot, would that be correct? That would only be able to be a one-structure lot.
So, let's see, it depends. So it's very constrained.
That's not what you said a few minutes ago.
So lot 1, so the current layout as proposed behind me is doable based on our regulations.
Awesome.
To talk about the developability of lot 1, if this were to be approved in this configuration, that would be a little trickier because lot 1 has there's a number of nonconformities. So there's nonconformities with the structure because it's too close, nonconformities with the lot because it's 72 feet. So there would have to be a lot of work done and very precise lines drawn in order for that lot to be further subdivided and developed. There's some work that needs to be done essentially because
The answer to any of the questions, any of the issues that you just raised, is that answer influenced by this subdivision?
is that answer?
I mean,
No.
this subdivision really doesn't change the answer to any of those issues.
No. So if you were to subdivide from the north to the south first, if you were to develop mainly off of Harbor Road, it'd still be really tough because of the narrowness of the lot.
Right.
And that it only has 72 feet of lot frontage, and especially if somebody wanted to keep the house, which I don't know if they could keep the house or not. I have no idea. So there's a number of constraints and considerations that need to be made if you were to develop from the north to the south that would have to play into this. But it's doable. It's just tougher than what they're proposing right now.
One last, if one lot was to be purchased, so that home would not need to be built on that same footprint
So.
in the regs as they are now?
Okay. So you mean for lot 1?
Lot 1.
Lot 1.
The old house that's there.
Okay. So,
Well, as a grandfathered structure, they'd have a legal right to build exactly where it is now.
Yes.
Exactly the same size.
Yes,
But that's grandfathered because it's already there.
yes.
Right, and that's my question. Could it only be there? If Lot 1 is sold, as is today, not Lot 2, would that house have to be, would a home have to be built on the same lot that it's at now?
Not necessarily, but it depends on whether, it depends on a number of different factors as well.
So, Ravi, though, just to,
Okay.
maybe this will answer his question. So if I own, the subdivision goes through.
Yes.
I own Lot 1.
Okay,
And I decide that I'd like to have a house on it, but not where the house is. I want to move it back further away from the road. And I come before the board and say, there are a whole lot of nonconformities here, but look, my proposal decreases some of the nonconformities because I'm putting the house further away from the road.
yeah,
Is that something that could be approved?
yes. It can be approved.
So no, well, first of all, it isn't changed by this subdivision, but no, the owner of Lot 1 isn't forced to use the house exactly where it is now. If they came up with a proposal that would make it less non-conforming, then they could come to the board and it might be approved.
Okay. Thank you all.
Thank you.
Hold on before we have Jim talk. I didn't know Jim was going to be talking tonight, and Jim and I had known each other through Boy Scouts, so I just want to let the board know.
Okay. And
I don't have a problem if nobody else does, but just for transparency,
Okay,
so.
Yeah, Mike and I have known each other for at least a decade, probably longer. Seems like longer.
Longer.
I'm Jim Brangan. I'm the neighbor at 393 Tracy Lane. My parcel is the one
Okay.
just to the
yep,
east.
just before I go too far, I got to swear you in.
Go for it.
Do you hereby swear or affirm that the evidence you give in the cause under consideration shall be the whole truth and nothing but the truth under the pains and penalties of perjury?
Yes.
Okay, thank you.
Okay.
Could you point to your lot?
Yes, I'd be happy to. This is my house right here. I have another odd-shaped lot that extends all the way out to the railroad track. There is a right-of-way that basically follows this for emergency access to the tracks. I think that was sort of mistakenly pointed to another parcel. So my house is right there. We've got the water line that goes through. I know the lot to my west very well, and I think that this is a good plan. As the neighbor to the east, I think that this is a good use of the property. My wife and I don't have any issues with the development as presented here. I would recommend that the driveway gets straightened rather than having that hook at the very end. The cul-de-sac is very tight, and garbage trucks can't get around it, let alone emergency vehicles. So I would recommend that that goes straight towards the, almost parallel the road for a little bit and then pop out towards the bottom. Because of the island in the middle?
Because of the island. The island, if you go out there right now, you'll see big tire tracks through the island. So that's an issue. And it's just something for safety, I think. But other than that, you know, I've been on the lot with Yerger and Becca. We've talked a lot. I think this is a good proposal.
Okay, thank you.
Thank you.
Any further comments, questions from the audience? Okay,
I'm Sean Armstrong, I live in the house on the
Okay.
west side.
Yep.
Oh, sorry.
gotta swear you in. Do you hereby swear or affirm that the evidence you give in the cause under consideration shall be the whole truth and nothing but the truth under the pains and penalties of perjury?
Thank you, thank you. And I know Doug, and I've met John as well before, but, so I live on the west side of the lot, and I also support this proposal. We've talked, I hope that we can keep as many trees, even though our boys have cleared a lot of the buckthorn. We know that they're not great trees in there, but we like the privacy. The ditch we lovingly refer to as a creek, so we're hoping to protect that as much as possible. But we'd be really pleased to have this go through as well and support it.
Okay, thank you.
Yeah.
Okay. Board members? Questions, comments? Do we have any motions?
So take it we're doing motion as a minor subdivision,
Yes.
and motion to finalize the record, close the hearing for application SUB 1912. I would move to direct staff to prepare a decision authorizing the applicant, laurie and Dickinson Consulting, on behalf of Jerker Codian. Okay, and Rebecca Breton to prepare a final plan review application for SUB 19-12 for a two-lot subdivision with the following recommendations. The applicant must include comments from the water quality superintendent regarding stormwater management with their final plan review application pursuant to town subdivision regulation section 800-4. And I believe that was it.
Okay. All in favor?
Aye. You got a second?
I always do that. Second it, Mark?
Second.
Okay, Mark seconds it. Now, all in favor?
Aye.
Aye. Motion carries. Oh, that's okay.
I know Ron.
Okay.
Somebody in the extension. If you look at the.
So we have-
Interest policy, read it.
Yep.
Talks about
Okay, one more item.
family relations
Extension request and.
9.A and 9.B.
and so forth, so just because you're acquainted with somebody.
Okay, guys, we ready?
No, it doesn't hurt to disclose it.
We're
We got
we're
some
not
more
done
business,
yet.
You guys, so, thank you.
Okay, we have a preliminary plan review filing extension request for sub 98-08R1 pursuant to the attached letter.
When do we extend?
It's
6 months?
6 months.
6 months.
Yep.
Okay.
Yep.
All right.
And there's
Okay.
no particular reason why this one shouldn't be granted, right?
I would make a motion to grant the 6-month extension.
Okay. All in favor?
Aye.
Aye.
Okay.
Duly approved.
So,
Okay. And the next item is board organization with Jeff's departure.
I think we're organized.
We will be looking for a new chair.
I think we're done.
Any comments, nominations, volunteers?
I think Dave's doing a great job.
I think you should be the chair. I don't want to move up from clerk. I'm going to propose Mark be vice chair.
Seconded.
All in favor?
Okay.
All in favor?
Aye. There we go.
Okay.
You ran slowest.
I was the clerk, you're the clerk?
This would be until March?
Yes.
We always-
So it'll be until town
It's the
meeting.
first meeting after town meeting, I
Yeah,
think?
it's another organization meeting. Yep.
Well,
Okay, well,
I'd just like to
everybody
make,
just needs to keep me honest, because I'm an office at this.
I'd like to make a statement for the record. Robbie, you've raised the bar here for our DRB administrators over the last 10-plus years, so we appreciate your service and your contribution and your patience and guidance and counsel, and we
You've
wish you
done a great job.
fantastic job, and we wish you the utmost luck and best wishes in your new endeavors.
We're the ones that need luck. He's going to do just great.
We'll come down once a week just to harass him.
That's
You
right.
can do it. You only have to be here the first and third Wednesday of the month.
Okay.
So
You
plan
can,
on seeing you as a member.
you can still call in if you want.
That's right.
Seriously, it was a privilege and honor working with you.
Yeah,
it was.
You did a great job.
Absolutely.
Absolutely.
In all seriousness, it's, we appreciate it and best of luck.
All in favor?
I just want to put that in the record, that's all.
Yeah, we have to adjourn, right? All in favor to adjourn, motion to adjourn?
Second.
Second,
All in favor?
in favor, aye, yep. Okay, we're done.